All right, we're about to dive into a truly landmark case, one that forced a major nation to choose between its long-held military traditions and the basic human rights of its own citizens. This is the story of Smith and Grady versus the United Kingdom. And trust me, it's about so much more than just the law. It's about the very real, personal cost of a discriminatory policy.
So let's just cut right to the chase with a question for you. Could something about your private life, something that has zero impact on how well you do your job, get you fired? For a few dedicated members of the British military, well, this wasn't some hypothetical. It was their reality.
To really get what this case is all about, we've got to turn back the clock a bit. We're looking at the UK's armed forces before the year 2000. And back then, the institution was run by a very rigid and, as we'll see, very exclusionary policy.
And here it is, the official policy from the Ministry of Defense, right there in black and white. It is so direct, so unambiguous. It really paints a stark picture of just how institutionalized this discrimination was. You see, there was absolutely no wiggle room here. And this is a really crucial point. This was not some kind of don't ask, don't tell situation. Oh no, this was a hard and fast rule that if your identity was discovered, it meant you were out. An automatic administrative discharge. Your career? It was over. Full stop. But a policy like this doesn't just exist on paper, right? It had a deep and profoundly damaging human cost. And that cost was brought into the spotlight by the very real experiences of people like the applicants in this case, Smith and Grady.
Okay, I want you to just imagine this for a second. Just a suspicion was enough to trigger a massive internal investigation. And these weren't just a few simple questions. We're talking about invasive, humiliating interrogations that were specifically designed to pry into the most private corners of a person's life. And if you want to know just how violating these investigations were, listen to this quote from the actual case files. Someone reported, "I was asked for the names of all my sexual partners." I mean, can you even imagine your employer demanding to know that? It's just a staggering invasion of privacy.
So faced with this impossible situation, the applicants, Smith and Grady, did something incredibly brave. They decided to fight back. But their path to justice, it wasn't going to be easy. It was a long, exhausting journey that would eventually take them all the way to the highest human rights court in Europe. Now, their entire legal battle really hinged on this one powerful idea, Article 8 of the European Convention on Human Rights. It's the fundamental right to a private life. You know, the right to be free from the state just barging into your personal business. This became the absolute bedrock of their case.
So their fight began at home in the UK, but they were shut down at every turn. The High Court said no. The Court of Appeal rejected them, but they didn't give up. They took their case all the way to Strasbourg, to the European Court of Human Rights, for one last shot.
And this is where it all comes to a head. The European Court was now faced with this massive task, weighing the UK's military policy against an individual's fundamental human rights. The stage was set for a truly landmark decision.
So the core of the whole debate was this. Does a country's interest in, say, maintaining military effectiveness, what they called fighting power, does that justify a massive interference with a citizen's right to privacy? That was the big question the court had to answer.
So, the UK government's position was basically that the ban was essential for morale and for operational readiness. But the court looked at that argument and found it completely hollow. The judges concluded that the policy wasn't based on facts or evidence at all, but on prejudice and just plain negative stereotypes.
And you can see in the judgment that the court really zeroed in on that human cost. They didn't just say the policy was wrong, they specifically condemned the investigations, calling them a particularly grave interference. The judges saw it for the deeply personal violation that it was. So what was the verdict? It was unanimous, a slam dunk. Every single judge agreed. The policy, the invasive investigations, the dismissals, it was all a clear violation of Article 8. It was a complete and total victory for Smith and Grady.
But the story doesn't stop there, not by a long shot. The court's decision kicked off a chain reaction, forcing immediate change and creating a legacy that, honestly, continues to influence human rights law to this very day.
As a direct result of that ruling, just a year later, the UK government really had no choice. The ban was officially lifted. That policy, the one that had ruined countless careers, was finally thrown into the history books. And the impact of this case was enormous. I mean, it didn't just change UK military policy. It strengthened privacy protections for everyone under Article 8. It became a huge precedent for LGBTQ+ rights all across Europe. And maybe the most important thing, it established this vital principle. A government can't justify discrimination based on prejudice alone. They need cold, hard facts.
And so this all leaves us with a question that echoes way beyond this one case. Smith and Grady, they drew a very clear line in the sand. But that tension between state security and our individual freedom, that's a constant negotiation. It forces us even today to keep asking where exactly should that line be drawn. Thanks for joining this explainer.